Next case will be in re Mardigian Estate. This will be a full grant with 30 minutes per side. Mr. Garcia.
May it please the Court, Paul Hudson on behalf of the respondents, and with me are co-counsel Mark Thomas and Joe Ahern. Your Honor, I'd like to reserve 5 minutes for rebuttal, and I will keep track of my own time. Your Honors, this case is about the Court's power to enforce its own rules of professional conduct. The petitioner here violated Rule 1.8c by leaving himself and his children $16 million in his client's will and trust. Rule 1.8c says a lawyer shall not do this under any circumstances, and the petitioner did it anyway. And we're here because after violating the ethics rule, the petitioner went to the courts with the will and trust in hand and asked the courts to declare them valid and enforceable despite his ethical breach. And now he argues that the court's hands are tied, that there is absolutely no way as a matter of law for you to keep him from inheriting the money. You can send him to the Attorney Grievance Commission for consideration of limited disciplinary measures like suspension or disbarment, but he says you can't keep him from taking the money. Now, we submit that that is a pretty stunning proposition. Why should an unethical lawyer ever be permitted to walk out of a Michigan courtroom with a chance at winning millions of dollars under a legal document that he prepared in violation of his ethical duties? And why should a court of law ever have to put its own stamp of approval on that regime? We submit that it doesn't have to be that way. And the rule that we ask the court to enforce is a very simple one. A lawyer who violates Rule 1.8c may never inherit under the offending documents.
Well, maybe we don't want to punish the testator.
Yes, Your Honor. It was the petitioner's duty to express the testator's intent in a legally enforceable document, and he failed in that duty. And so the question is, what happens next? Does he get a chance to inherit under the documents when the rule says he shall not do this under any circumstances? Or does the court say that this is a bright line rule, shall not means shall not, and when a lawyer violates that rule, the result is that he cannot inherit? And we submit that that result flows from a fundamental principle, and that's that this court has plenary exclusive constitutional authority to regulate the practice of law and the conduct of all lawyers in the State Bar of Michigan. This is the court's domain, not the legislature's, and so this is one of the rare circumstances where the court can't wait for the legislature to ride to the rescue and solve this problem for us. It is up to the court to enforce its own ethical rules. And so how should the court do so? Well, the petitioner is right that the typical way that the court addresses disciplinary matters is through the attorney grievance process. But it is a different story when the unethical lawyer comes to a court and asks the court to enforce a document that he prepared in violation of the rules. In that context, the courts have always said, since the enactment of the rules in 1988, that courts have a duty and an obligation to enforce the ethics rules by refusing to permit the lawyer to profit from his unethical conduct. This court has said that the Michigan rules of professional conduct are definitive indicators of Michigan public policy, and a court of law simply never has to enforce a legal provision that violates public policy.
If they're definitive, counsel, MRPC 1.0 subsection B says failure to comply with an obligation or prohibition imposed by a rule is a basis for invoking the disciplinary process. That's all it says.
That's correct, Your Honor, and it says that the rules do not give rise to
Is there some negative implication that gives rise to, possibly?
I think what Rule 1.0 says is that it does not give rise to a cause of action for enforcement of damages under the rule. But what it does give rise to is a public policy violation by the lawyer. When he violated Rule 1.8c, he violated Michigan public policy. And a court of law should not and cannot be forced to enforce a provision that violates public policy. And I think that's the central flaw of the in re powers regime that the petitioner asks us to revive here. Courts shouldn't have to play wingman to an ethical violation. And worse than that, the powers regime actually incentivizes lawyers to breach the rule. It, by definition, creates a path for a lawyer to inherit despite violating the rule. And so, by definition, it incentivizes a breach. And so when the pot is enticing enough, when, say, it holds $16 million, then lawyers are going to be tempted to violate, to risk the disciplinary sanctions for a chance at inheriting the fortune. And
so counsel, good morning. And
good morning,
I totally hear your argument. But this is, I think, what makes this challenging is there's kind of a balance. And the question here is that we're focusing on kind of the actions and the conduct of the lawyer and the impact upon the lawyer for doing this. But how do you balance this with the wills and the passion and the reason that the person who passed on perhaps did this? And I guess that's what makes this so hard, is that you're dealing with a situation where you have a circumstance where a person has passed on and is no longer with us. And at the end of the day, how do you help us to balance this idea? You know, I realize that there's a lot going on here, but how do you help us to balance this idea that you have a person who's no longer with us, who had wishes and concerns, or this was what they allegedly wanted, with the punishment or the malfeasance of an attorney?
Yes, Your Honor, and I think that's a very important question. And I think the Attorney Grievance Commission in their amicus brief put this perfectly, and better than I did in my brief, to be honest. Quote, "The time for the legal profession to protect the testator is before the will is drafted, not at some indeterminate future date when the testator's lips are sealed by death and litigation is underway in the probate court." It was the petitioner's legal duty, his ethical duty, to express the testator's intent in a legally enforceable document. And this court has always said, it's of course true that we want to honor a testator's intent. But what this court has said is that it is the duty of the courts to carry out as nearly as possible the intent of a testator insofar as such intent has been expressed in the lawful provisions of a will. And that's from the In re Howlett's Estate case. Form matters in this context, especially matters in the context of a will and trust. I could announce to this courtroom right now that I want to leave my vast fortune to Mr. Thomas, my vast fortune of, old baseball cards and a weed whacker. But unless that gets reduced to a legally enforceable document, he is out of luck. And it doesn't matter that there are 6 Supreme Court justices as witnesses, a courtroom full of people, and a half dozen people watching on the live stream. He could have a great case that I really did intend to leave my money to Mr. Thomas. But it has to be expressed in a legally enforceable way, and that's what was not done here.
But the statutes tell us that that's the way it has to be done.
The statutes certainly set up a framework, and I don't quarrel with the fact that it is generally the legislature's domain to set the substantive law with respect to creation and enforceability of trusts. But it is never the case that a court has to enforce a legal provision that violates public policy. And that's especially true here because
in your free fire zone, you said that we've made it clear that the rules of ethics are expressed the public policy of the state. I don't think it was that clear in Turian v's Witt. They may, and I suppose there's an argument that could be made that this is public policy of the state. But Ethic also makes it clear that the public policy of this state is to honor the intent of the testator. And if we conclude that the statutes require at least the opportunity, we follow powers and say there's an opportunity for a jury to decide what the intent is. Why is that a bad result?
It's a bad result because at the end of that powers process, so number one, it incentivizes breaches of the rule, which I said. But number two, at the end of the jury trial on a factual issue about the decedent's intent, a court of law, ultimately this court, is going to have to declare to the Michigan public that this will that was prepared in violation of Rule 1.8c is valid and enforceable. It was a public policy violation in and of itself for the petitioner to prepare the will and leave himself a substantial gift.
It was a violation of the rules of conduct to do it, and the rules start out by telling all lawyers that if you violate these rules, this is the subject of discipline.
And the courts have also instructed that it's not just a matter of discipline when the lawyer comes to the court and asks a court to enforce the document. The courts in that circumstance have said that they have a duty and obligation not to let the lawyer profit from the ethical violation. And here, Your Honor, we also have, in addition to that general principle that a court never has to enforce a provision that violates public policy, we also have an express invitation from the legislature in EPIC for the courts to declare valid any provision in the will or trust whose purposes.
Are you relying on MCL 700.7404 and 77410?
Yes, Your Honor.
You know, I disagree with your interpretation of those. Those actually say that the trust is unenforceable if its purpose violates public policy. All right, the purpose here is to make a bequest or to dispose of assets. It's not a violation of public policy for a will to be written to dispose of assets. What you're objecting to is the drafting, not the content.
I understand the argument, Your Honor. I submit that is an overly restrictive reading of what the purpose of this trust is. The purpose of the trust, as this court is now viewing it, is to leave a substantial gift to the lawyer who prepared it in violation of Rule 1.8c. So I think the purposes there encompass the purpose to leave this money to the unethical lawyer.
Well,
but even
let me expand it. The purpose is to leave a gift that violates the rules of professional conduct, but may be consistent, and a jury would have to determine this if the money is to go that way. But then it would be the purpose would be to also honor the testator's intent.
Rule 1.8c says nothing about undue influence. You can violate the rule simply by preparing any instrument, giving the lawyer or a person related to this lawyer's parent, child, sibling, or spouse any substantial gift. So the rule violation happened when he prepared this will and trust. And now the question is, so that was a public policy violation.
You keep saying it's a public policy violation. It's a violation of the rule.
If it's not a public policy violation for a lawyer to blatantly violate a rule of professional conduct drafted by this court that says a lawyer shall not do this, then I don't know what a violation of public policy could be. This court has instructed that rules of public policy may constitute definitive indicators of public policy.
If the lawyer drafts a will and in the course of drafting the will violates the rules of professional conduct in some way, does that make the contract void?
To the extent that the lawyer then attempts to benefit from it, and that's the result from all of the cases in this area. The Evans and Luptak, the Abrams case, the Spiker case, the Morris and Doherty case, that when the lawyer violates Michigan public policy and then comes to a court and asks the court to enforce the document, the court simply will not and cannot do that. And the courts have said it would be absurd if an attorney were allowed to enforce an unethical instrument through court action, even though the attorney is subject to professional discipline for it. And violating lawyers have made the argument that the most they can do is the courts can do is send them to the Attorney Grievance Commission. And I think the Court of Appeals in the Evans and Luptak case said this exactly right, that it fails to understand the proper role of the court regarding the ethical conduct of its officers, and that Michigan has a long tradition of judicial oversight of the ethical conduct of its court officers and have taken affirmative action to enforce our ethical standards and rules regarding counsel. So it's not the case that when a lawyer comes to the court with a legal document prepared in violation of the rules of professional conduct, that the courts just have to look the other way, send the lawyer to the disciplinary authorities for disciplinary measures, all the while enforcing the unethical provisions in the document that the lawyer prepared. Your Honors, the court asked us to address whether the in re powers regime is a workable rule and protects the testator's intent. I think that bright line enforcement here is the way to honor a testator's intent in the most cases, in the next 100 cases that are like this one, because bright line enforcement tells all lawyers that this is simply something they cannot do and there's no incentive for doing it. And so if they have a friend who asks them to prepare a will and they want to inherit under that will, they are incentivized to take it to another lawyer because that's the only way that they can inherit. And so a bright line enforcement incentivizes the right sort of behavior and results in testator intent being honored in all the cases. And stepping back one step, Justice Bernstein has always instructed me to keep this simple. And a lot of these arguments are going down a lot of different paths, and I think we have answers for all the issues. The only way the court gets to any of those arguments is if the court thinks there is some lack of clarity whether a lawyer can draft a will in violation of Rule 1.8c and still inherit. And I submit there's no lack of clarity in the rule. If I tell my 7-year-old that you shall not steal your sister's Halloween candy, and he does it anyway, I can tell you there's no lack of clarity in my house whether he can say, okay, you got me, you can send me to my room, but boy, I get to keep the candy. It's the same principle here. The shall not, implicit in the shall not is that if you violate the rule, you will not be permitted to keep the fruits of your violation. If you shall not rob a bank, you don't get to keep the bank money once you steal it.
But all these arguments just ignore the public policy that we want to enforce the testator's intent.
We want to enforce the testator's intent insofar as it is expressed in a valid legal instrument. That's always the predicate for whenever the court says that the testamentary intent is the polar star that we want to.
Right. And whether it's valid and legal, it's a circular argument. It's unethical. The question that we're here today to decide is whether it's valid and legal.
You're right, and I submit that because there is a public policy violation, that by violating the rule, and a court cannot enforce a legal provision that violates public policy, that this expression, this specific gifts to him and his children are void as a matter of law. And then what we're left with, fortunately here I think, is that the decedent expressly contemplated that there were going to be situations where a provision of his will and trust could fail. And he specifically intended in his will and his trust,
right.
He built in contingency
we'll follow
clauses.
His intent, but on the first point we won't.
We will, what we're asking the court to enforce is the only legally valid expression of the testator's intent that we have, and that's under the contingency clauses of his will and trust. Everything else was stymied by the petitioner because he failed to reduce the testamentary intent, whatever it was, into a legally enforceable valid document.
Counselor, so I think isn't there a relationship between, maybe this is what you mean, between the lawyer's ethical violation, let's just call it that because I think we can all agree it's that, right?
Right.
And
yes.
The testator's intent. I mean, I'm wondering, how do we know? We absolutely, we have guidance from the legislature that the testator's intent has to be our guiding policy in this area of the law. My question is, when a lawyer has violated a mandatory rule, maybe different from back in Powers days where a lawyer kind of, violated this is probably a bad idea, sort of a preference against it. But when we have a lawyer who violates a mandatory rule, doesn't that give us pause in figuring out what the testator's intent was? So normally when I try and figure out what the testator's intent was, the first three things I might look to figure out, one would be ask the testator, well, he's gone, we can't ask him. The second might be look at the instrument and the plain language in the instrument. But if that instrument is fundamentally compromised, I don't know how much credibility to give it, right? And then the third would be ask the lawyer who drafted it. Well, the lawyer who drafted it stands to gain a whole lot from it. So my first three go-tos in how to figure out what the testator's intent are not helping me much here. So why aren't you telling us, absolutely, you have to enforce the testator's intent. We just don't know what it is in a case where a lawyer has jumped over this line.
I think that's exactly right, Justice McCormick, and I think what the bright line prohibition against this in Rule 1.8c recognizes is that this is an inherent, incurable conflict situation. It's listed as a prohibited transaction, and you're right, it's inherently suspect. We simply do not know what the testator's intent is because this lawyer has violated the rule of drafting it. Now, they say, well, then let's go have a jury trial to figure it out. But I think the wisdom of this rule is no matter what, I mean, it's a non-waivable rule, which means that even if the testator had alongside this will said, yeah, you know, I know my lawyer is violating this ethical rule and it doesn't bother me because I really want to leave the money to him, that would be still unenforceable. And one situation that I've been mulling over in my head is, okay, let's say that the decedent at this one point in time really does want to leave his money to his buddy, the lawyer. That's in his heart, that's what he wants. And the lawyer writes up the will and leaves it to himself. But then, you know, years go by, decades go by, as you're approaching death, you reconsider your affairs. If you have a neutral lawyer, it may be the case that you say, well, you know what, I want to benefit my lawyer buddy, but I also want to benefit my family. And if you have to pick up the phone to call the lawyer who is benefiting in the will and saying, I'm going to take money out of your pocket and put it in somebody else's, then you're incentivized not to do that. And so we will simply never know in any of these situations what the true testamentary intent was.
After this was done, though, he consulted with another lawyer, Bonaventure, whatever.
And Your Honor, I'm cognizant of the procedural posture of this case, and under the individual facts of this case, I'm not going to quarrel with where the decedent truly intended to leave his money in his heart of hearts, or whether there was undue influence. Those would all be factual questions. Our position is that
well, that's your answer as to why you didn't pursue the argument that Justice McCormick suggested.
There is a wide spectrum of factual scenarios that we can imagine under this rule. Some are going to be the lawyer who just, you know, the decedent really did want to leave the money and the lawyer just screwed up. And then on the other side, we're going to have the truly crooked, unethical lawyer who's trying to write himself into a client's will.
Well,
I think the point here is that
the possibility of a spectrum is that's why you let it go to a jury and people get to. So why not? Given that there could be a spectrum, why isn't the right answer?
Because there's absolutely no spectrum under the rule. The rule says shall not, under any circumstances, ever do this, and it doesn't say you shall not do it unless you can prove, you know, to a jury that you didn't exert undue influence, or that this is really where the testator intended to leave the money. The rule says simply shall not do it.
Would you agree the best indicator of public policy for the state of Michigan would be our statutory laws?
I think in this context, the best indicator of a public policy with respect to this specific situation, we have a rule of professional conduct that speaks exactly to this situation. And so the best indicator of public policy, particularly given the Supreme Court's plenary exclusive authority under the Constitution to regulate the practice of law and the conduct of lawyers, the public policy of Michigan is expressed in Rule 1.8c, which specifically addresses this.
Statutory law is not the best indicator of Michigan's public policy.
That's correct. In this context, given the Supreme Court's exclusive regulatory authority in this area.
And regulating lawyers and drafting these rules, we've indicated in 8.10 that the purpose of the rule is for discipline.
The purposes of the rules are for discipline unless the lawyer is trying to profit from it through court action, through a court declaring that it's. The court has said that in the Abrams case, where it said that a violation of the rule.
So our case law is a better indicator of public policy than our statutes.
I'm sorry, Your Honor.
Well, I'm trying to discern. It seems to me I've got arguably a conflict of how to determine the public policy of the state.
And I submit that the clearest indication of what is the public policy with respect to lawyers preparing and taking under a will where they're receiving a substantial gift from a client
Can I
is the rule that expressly addresses that issue
Can I
and not
suggest
more
that you
general
might-
issues.
Is it possible you might both be right? I mean, isn't it, you don't disagree with Justice Zara that the EPIC policy, the legislature expresses the policy in enforcing wills and trusts, right? I mean,
That's right.
And they do that through their statutes, and obviously we can't, we can't by common law override legislative policy on wills and trusts. But it may also be the case, you may also be right, that we have one little tiny area where we get to express the policy of the state, and that's with respect to governing lawyer conduct.
Exactly right, Justice.
So you both might be right. It's just in this case, how do we balance those two competing expressions of the policy of the state of Michigan?
And then just I'll add an addendum, particularly when we start the rule by saying the purpose of the rules would be for discipline.
I understand, Your Honor, and I think because this is in the area of regulating the practice of law and the conduct of the members of the State Bar of Michigan, that this is squarely within the Supreme Court's authority, and therefore the Supreme Court, through its rules of professional conduct, sets the public policy with respect to whether a lawyer can inherit or not. And I submit that the legislature, in fact, because this is the Supreme Court's exclusive constitutional domain, could not legislate in this area, even if it wanted to, in any direction, saying a lawyer who violates Rule 1.8c either can inherit or can't inherit or can inherit only under certain circumstances. That, I think, would be a infringement on this Court's exclusive constitutional authority and therefore a violation of the separation of powers. Your Honors, I know I've gone long here. I'd like to reserve whatever I've left for rebuttal.
Counsel, I'd like to ask you, what weight do you give to the fact that the current rule, Powers, preceded by Donovan versus Bromley, goes back about 125 years? What is the weight that you give to the fact that our contemporary rule has that history in provenance?
It is certainly a factor for the Court to consider, but I think the more salient factor here is that there used to be no rule set in stone in a rule book that said a lawyer shall not prepare one of these instruments. The law changed in 1988 when this Court enacted Rule 1.8c, and it now says, without any hesitation or ambiguity, that lawyers shall not do this.
I mean, in focusing upon the lodestar of testator intent, I mean, it seems to me you give fairly little consideration to two aspects of the rule that's existed in the state for 125 years. One is the fact that the bequest in question was presumably set forth in the document, in the will, preceding the testator's passing, and presumably the testator was competent. And secondly, the lawyer who has taken the bequest has presumably rebutted the presumption in court, a presumption that, with evidence presumably that would be persuasive of testator intent. In other words, there is a will in place that should be given some presumptive initial effect, and there is a legal process by which the presumption is put into play and presumably determined by the judicial branch.
And it's always going to be the case in one of these situations where there is a will that's drafted by the lawyer that purportedly expresses
That's exactly why the
current
current rule has the provenance that it does.
But then, Your Honor, I'm sorry, the second part of your question was?
That the presumption
The presumption of
has
undue
been
influence.
rebutted, presumably.
And I think the Attorney Grievance Commission's amicus brief did a superb job of showing why that is barely any protection at all. Under the law of presumptions as it existed under Powers, that may have had some teeth because it was an actual conditional inference. Now it has no evidentiary value at all. And all the lawyer would have to do to burst the bubble of that presumption is come forward with any evidence, really, that this is where the decedent truly intended to leave him the money, and then the presumption.
There's no case law that any evidence set forth by the attorney who's taken the bequest in an effort to rebut that presumption is enough to rebut the presumption. I mean, presumably, the presumptions that have been rebutted on the basis of whatever the totality of evidence is that's been introduced by that attorney. It's not any evidence. It's evidence persuading the court that the bequest was a legitimate bequest and it shouldn't be called into question by the fact that there was some ethical question underlying it.
I think it should be, if the court were to go down that road and affirm this in Ray Powers' presumption of undue influence, it would have to make clear that it is a real burden for a real hurdle for the lawyer to clear.
Well, what would you do to clarify that? I mean, it's a good point you make. I mean, if courts have been engaging in shortcuts in allowing this presumption to be rebutted, how would you identify that problem, and what would you do to address it?
I think it would have to be overwhelming evidence that this is where the decedent intended to leave the money, and that there was no undue influence whatsoever, and the fact of the attorney-client relationship would give rise to a very strong presumption of undue influence. But, Your Honors, to be clear, I think no matter how strong or weak that presumption is, this court creating a path for the lawyer to inherit necessarily incentivizes lawyers to breach the rule, and I think that's exactly what is just untenable about the in Ray Powers regime.
That's a pretty strong statement that it incentivizes misconduct.
That's exactly what it does. By creating a path to recover millions of dollars, if you violate the rule, the lawyers are going to be tempted to risk the disciplinary sanctions of suspension or disbarment for a chance at winning the fortune. And I think that's exactly what Rule 1.8C's absolute prohibition was intended to
Do you have any evidence that we have a history over the past 125 years of having more cases that have incentivized misconduct because of the prospect of $1 million out there, or disincentivizing that same conduct because attorneys have lost their profession, they've lost their license to practice the law? What's been the practical, real-world experience over the past 125 years of what incentives and disincentives have been produced by the rule that we have in place today?
I think the rule since 1988 has been crystal clear. Lawyers shall not do this under any circumstances. If the court opens up a path for the lawyers to inherit despite violating the rule, that by definition incentivizes lawyers to breach the rule.
So you have no empirical evidence of one sort or another?
I think the clear absolute prohibition since 1988 has worked effectively. If the court makes that not a clear rule and says that lawyers can violate the rule and still have some path to inherit, then we may very well have a lot more of this sort of case.
And what's wrong with the argument that Justice Zara has raised several times, though, that at the end of the day, we do have to balance that disincentive, if in fact it's arisen in cases, including this one, with the fact that we want to facilitate testator intent?
The job to express the testamentary intent is up to the lawyer. And if he violates that, if he doesn't get that job done, then he's going to be bearing the consequence. And if there's absolute enforcement, then that's the regime that we will have. Thank you, Your Honor.
Thank you, counsel.
Good morning, Mr. Chief Justice. May it please the Court. David Garcia appearing on behalf of Mr. Papazian. Along with me at counsel table, two of my colleagues, Ms. Jake Bobrosi from my office, also Mr. Dan Paluga from my office. I want to start by focusing on, obviously, the three questions that this Court has presented in its July order, all of them revolving around this framework of powers. And although I'm going to address all three, what is underlying them, and it's come out this morning as well, is the fundamental one question between them all, and that is whether the powers regime of the two, what I call the two silo systems of a jury trial on undue influence to determine intent, testator intent, and a separate proceeding in the AGC department to determine what, if any, discipline should come out of the lawyer's conduct, is in fact a workable rule. And what I'd suggest is the simple answer, yes, but the more detailed answer is it works and has worked, as you, Mr. Chief Justice, pointed out, for 125 or so years.
I didn't point out, I asked.
Very fair distinction. I will point it out that going back to 1897, this rule has actually existed, not just since Powers. But the framework of Powers and its preceding cases works because in that system, facts matter. And I realize the Court's concern here is very far-reaching and it's certainly not limited to the facts of this case, but I only want to mention 4 facts of this case very quickly. And it's why these facts are critical and should be critical to the outcome of this case. First is written communication from the deceased himself. I'm talking about things aside from the will and trust that they call into question. Written communications back and forth between the lawyer and the deceased, where the lawyer asks for nothing, the lawyer doesn't suggest he should get anything. The lawyer says, you've asked me to do your will. You decide, all caps, you decide who gets what. Make lists. Tell me who gets your personal property, your artwork, your whatever. And the decedent writes back saying, there's a few specific things for some other people, but you, as my lifelong friend, get my property. That's in the decedent's own hand. And the lawyer carries out not only that request, but the individual specific requests that have nothing to do with him. And that's what ends up in the signed document. Second fact, independent advice from not just lawyers, but sophisticated financial consultants at Comerica Bank, who provided this individual testator with reports and spreadsheets and slideshows about here's the estate plan that you have and here's how it's going to be effectuated when you pass, all of which he clearly understood from the testimony of the witnesses involved. Third, opportunity to change. This is an individual who revised his estate plan many, many times over the last 20 or so years of his life, and many, many times even when he was involved in working with the appellee here, Mr. Papazian, all of which during those times he could have changed anything that he either didn't like or had changed his mind about. And finally, the fourth fact is at the end, I think it was you, Justice Zara, who mentioned this other lawyer. At the end, he receives totally distant advice from another lawyer named Bonventre, who says, and I'm just going to read what his testimony was very quickly, Bobby was basically saying that if he didn't do anything, the way things are written now is fine. And to me, that meant his current documents that he had already signed were fine, and that's the way I took it. And that happens within a matter of a few weeks before his death. Those facts, and the reason I took just a few minutes to run through them, are important because in this regime, here's a perfect way to make sure you never get to testator intent. Adopt a bright line rule, because their facts, I think even they would admit, mean absolutely nothing. The only inquiry is, how was the document prepared? And if it was prepared in a way that we find questionable, we will conduct no further inquiry. We won't care about what any of the witnesses say, what any documents say. We will simply impose a bright line rule that says, testator intent has become irrelevant. We don't inquire into it. I would suggest that that would be the worst outcome and the worst conflict with the public policy embodied in the probate code and specifically EPIC. Now, the other thing that has come up in some of the briefs is what I guess could be called a slippery slope argument, but what I call the worst case hypothetical is, okay, if we have a case here where there is independent evidence and there is, at least arguably, reason to conduct a trial about testator intent, what do we do about the horrible example, which has nothing to do with the facts of this case? The lawyer who goes into the nursing home to a client he's just met and procures some kind of will or trust or gift to himself. And I would suggest to you that the powers rule, the dual silos, works well in that situation too. First of all, in those kinds of egregious facts, they don't discuss ethics opinions. They don't really cite to the sort of evidence that you, Mr. Chief Justice, were asking about whether this incentivizes bad behavior, whether there's been an uptick or a downtick in terms of grievances.
It's egregious facts. You've stated that. I'm not sure what level of egregiousness we have here. I'm still not comfortable with what occurred. But let me just take a step back. Mr. Hudson says throw Powers out, you like Powers. In 2012, in a denial app in Ray Mortimer, then Chief Justice Young wrote a dissenting statement. He would have granted to consider what burden of proof should apply. He believed that the will's proponent need only come forward with substantial evidence of rebuttal. And he was concerned about the possibility or his conclusion that the law could be read to actually require a preponderance of the evidence that no undue influence existed. Mr. Hudson, towards the end of his argument, said the standard or the burden of proof should be a very heavy burden. I'm not sure if that's more than a preponderance. Articulate for me, if we are going to keep Powers, and I believe that this burden to overcome the presumption is gray or unclear, as Justice Young indicated back in 2012, why wouldn't we then impose the requirement that the proponent of the will overcome the presumption by clear and convincing evidence?
And thank you for that. There are two parts that I want to make sure don't get confused, because I think this is an important question, and it's this idea of clear and convincing evidence is potentially being a relevant standard. I don't think was actually briefed by the parties. I believe it came from maybe the probate section's amicus brief. But there are a few issues in play. One is the presumption, and one is the ultimate burden of proof, which obviously are very different things. When you were speaking about the Mortimer case a moment ago, I believe that was focused on the level of proof, substantial evidence or something else, of what was necessary to push back at the presumption. I would suggest that there are two things that the court should look at in terms of if it starts walking down the pathway to considering actual burdens of proof, switching them from one party to the other. Because I don't think it's actually permitted under EPIC, because there's a statute on this. Specifically, I'll quote from it here in a moment, Section 700.3407 has a few relevant provisions, but I'll read sections C and D. Section C says a contestant of a will has the burden of establishing lack of testamentary intent or capacity, undue influence, fraud, duress, mistake, or revocation. The next section, Part D, a party has the ultimate burden of persuasion as to a matter with respect to which the party has the initial burden of proof. So translated and applied here, the contestant, the appellant here, brought a claim of undue influence. They filed that claim in the court below. What EPIC makes clear is that that party, as the contestant, never loses the burden of proof. It has the initial, it has both the burden of persuasion and the ultimate burden of proof on the issue. Now, in between, the court has, in Powers, among other places, come up with a shifting mechanism for the presumption. But I wanted to make that statute clear as what the probate section suggests, and what I think I heard Brother Counsel raise this morning, is the idea of entirely flipping the table over and going from burden is on this party to now burden has shifted to this party. And I think EPIC, as a matter of substantive law, has addressed this and said, no, 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 the contestant has the burden up front and has the burden in the end. In the middle, the court can create a rebuttal or an inference, but the burden of proof is always here. I hope that answers the first part of your question.
Well, it's a tough case. I mean, what's going to take to overcome the presumption? In all cases of presumption, is it simply substantial evidence? It can never be more. In light of our ethics rule, can it not be something more than that? No,
and I think actually, if there is an area to clarify both Mortimer and perhaps even Powers itself, that this is the area that does not infringe upon the probate code, is to talk about the issue of what is sufficient to rebut that presumption once the three elements have been proven by the contestant. And I think, as a first matter, the court should be cognizant of the legislative scheme and the same policies we've talked about this morning. I won't repeat all of them, the testator intent, the maintaining of the ultimate burden on the contestant, and the like. But I think while respecting that, the court certainly has some flexibility in determining what's enough under Powers to defeat this presumption. I think this is where, if the court so desires to go down this road, It can address what I called earlier the horrible example, the person in the nursing home sneaking something into a will. Because I think if I heard Justice McCormick's question from a little earlier, you were sort of running through, well, first I'd look at the will, and then maybe I'd talk to the testator, and maybe I'd talk to the lawyer to try to discern intent. And your question points out a very valid issue, that if you have an interested lawyer as the only party who could perhaps provide relevant testimony, and that person is interested, should it be enough? This is my question, not yours. Should it be enough that the lawyer just comes in, signs an affidavit, and says, I swear I didn't mean to influence anybody, and that's enough? And I think here, we would have absolutely no issue, given the facts of this case, with the court saying, that's not enough. As I ran through at the beginning of this argument, there's certainly more substantial evidence than that. And I think it could be fashioned a lot of different ways, but in terms of clarifying that, it could be done by saying substantial, which I think is still a little bit of a squishy term.
Less than a preponderance.
Correct. I think it could also refer to the types of evidence that would be sufficient. For example, third-party evidence. But I think the court can address the horrible hypotheticals posed by the other side, which are not in play specifically in this case, by simply adjusting the modicum of evidence necessary to meet the presumption.
But
and
counsel,
it would address a wide range of issues.
Sure. And counsel, good morning. And I guess this is the question I have, is in terms of addressing that point that you're moving on to. What was I noticed, and I was curious, to the best of your knowledge, what was the disposition of the AGC in terms of what was their finding as it pertained to this case in regards to what their penalty was?
There is none.
That's what I thought. This is going on for 5 years, right?
If I have my years correct, the lower court granted summary disposition in the case at the end of 2013. Virtually simultaneously with that, a grievance was filed.
Right.
And we are now
I guess
roughly
the reason
4
I'm
years
asking
later.
that question is so your client is still ultimately practicing law, correct? With any restriction by the AGC at this point?
No, he is. He is practicing with no restriction.
Okay. And the reason I ask that is that, and it is true, what Brother Counsel says. I do like to kind of keep things relatively simple. And so when we're trying to, your argument that it's really that you're no longer going to adhere to the testator intent, if you were to just try to simplify this, help me to understand, wouldn't it just be best if you have this bright line rule that says, look, this is like fire. If you touch it, this is going to happen. This is incredibly clear. Under no circumstance, under no situation can a lawyer perform this duty. Can a lawyer write a will and put themselves into it? In a way, help me to gather why that wouldn't just be the most simplistic, red line approach that is clearly understood by all people that say, don't do this, because if you do this, this is what's going to happen, rather than where we are right now in a nebulous situation, which is very unclear, and at this point, as it pertains to your client, it's really uncertain as to what penalty, if any, he's going to face from the AGC.
Well, to take the last part of that first,
Sure.
what penalty he may face is going to tie directly to the facts as I've talked about them this morning, because on the one hand, there's the egregious end of the spectrum, and I know the court is not going to pass on this issue, but what we believe is he tried to do what his client wanted him to do. That was the tail of your question. I think the simple answer to what your larger question was, why not just a bright line rule? Because I would submit I cannot think of an action or a rule that this court could implement that would be more fundamentally adverse to the idea of trying to discern testator intent, which is, as
Is that for this particular case or for all future cases?
I'm sorry, I missed the beginning of that.
Is that for this particular case you're speaking or for all future cases? Because it would seem if we did it going forward, it would be pretty clear, right, for future cases?
Well, there's no question that we would be clear. I don't deny that a bright line rule is clear. The issue is when a client, a testator, is punished because of what is set forth in a rule of professional conduct. And it may well be clear, and it may well be a bright line rule, but you also, and this is...
I mean, I don't want to get into the facts because I don't think they're really relevant either, but your client was told, or the testator, I should say, was told that this was problematic. And he said, well, I'm going to change it anyway, right? Doesn't matter.
Well, not that he was going to change it anyway. I mean, he
Something
knew
like
it, but
that.
he's obviously a lay
We're going to make
person.
more changes later.
Yeah.
We're going to do whatever he said. I don't even know what the facts are, but I listened to your argument today. It's sort of interesting because you guys are like two ships passing in the night. Either the ethics rules have an impact on the case, or apparently your position is no bearing at all.
Well, and actually, let me move to that specifically.
Let me focus the inquiry because we listened a little bit about what heard that the powers rule incentivizes violations of the ethics rule, and I imagine you don't agree with that. But I guess my question would be, what impact do you think the powers rule has on 1.8c? The
impact of powers on...
The powers rule. What impact does it have? If it doesn't incentivize it, does it have any impact? What are the relationship? We're sitting atop the mountain, right? We're in charge of both the ethics rules and the substantive common law rule of powers. Mm-hmm. And we have two that are in somewhat of a conflict, it would seem. And I'm trying to ask you to help me resolve that conflict, if there is one, or if you think there's no relationship at all, there's no correlation at all. I guess I'm interested in knowing that too.
No, it's what I would say about the relationship is, of course, powers coming first, the passage of 1.8 coming later. There hasn't been any evidence presented in this case to the court about whether there has been a spike up, spike down, or spike sideways in terms of supposed violations of Rule 1.8.
But part of what we're trying to decide today is whether to continue the common law rule of powers, right?
And to that, I think it is not at all unreasonable for this court, in looking at a precedent that goes not just back to powers, but back into the 1890s, really,
But something changed, right? Something changed. 1.8c was enacted, and the question of this case is, does that matter, right? That's what I'm trying to focus on. And that's why I want you to talk about it, because I think it's the only reason we're here, to talk about, did 1.8c change anything that should cause us to revisit powers?
Sure, and I think the first part of that answer comes from former Chief Justice Young's opinion in McDougall, because there are some steps here. And the first part is, in McDougall, the court really went through and tried to delineate where are our powers of substantive law, where is our power of rulemaking, and how do these things interact with each other, particularly when confronted with a legislative enactment that may or may not come into conflict. And a few things that the McDougall case said I think are very important here. First, that it cannot be denied, quote, that this court is not authorized to enact court rules that establish, abrogate, or modify the substantive law. That's a 1999 case. So first, clearly demarcating where the court's rulemaking authority can touch on substantive law in this case, although that case didn't deal with it. In this case,
I agree with you. The rule itself doesn't have a substantive impact.
And the second part, the court went on to be a little bit even more specific than that. Rather, this is a quote, rather, as is evident from the plain language of Article 6, Section 5, this court's constitutional rulemaking authority extends only, the emphasis there was in the original, only to matters of practice and procedure. So I bring this up because your question was, well, didn't Rule 1.8 change things? And I think the first answer is, no, it's not a substantive rule of law. The second answer is more factual, and I don't think in this case that the change from the former code to Rule 1.8 really had any effect or should have any effect on powers. Here's why. A fair reading of the powers case is absolutely that the court recognized that in a scenario where a lawyer drafts a will for a client, there's a significant ethical violation. There was no shall not rule at the time. That is conceded. That's very clear. But I think
there was really no specific rule on point, right? There was sort of a general rule that frowned on this kind of stuff.
Well, it frowned on it, but when you read both powers and the cases that come well before and even after, they don't say that we frown on it. They say we're finding this is an ethical violation of professional responsibility. Again, I think that's...
that language is in there, but they find that it's suspect activity, right? It should be viewed with suspicion.
Viewed with suspicion in terms
doesn't
of...
reflect well on lawyers who do it.
I think the viewed with suspicion language is that we would view the resulting documents that way.
Right.
I don't think there's a lot of gray area, at least in my reading of those cases, that they were somehow endorsing the conduct, or I guess to put it a little bit better, those courts, including Powers, were not declining to implement a bright line rule because they said, well, maybe drafting a will in these circumstances isn't really a problem. Maybe it's okay. They acknowledge it's a problem. But what they said is, we're going to have this presumption of undue influence in a trial on the issue of that and intent, given some of these other policies that we're all here talking about today. I think to sort of turn that around a bit, the appellant's argument would be a lot stronger about the importance of Rule 1.8 if Powers or any of those other earlier cases had said, we're not going to implement a bright line rule because under the current code as it exists, there's no real prohibition against this. It's really okay for a lawyer to do. None of the cases say that. They all go the other way.
But that's clearly part of the factual predicate that was going on. There was no mandatory rule in Michigan or anywhere else at that time, right?
No, correct, and there still is not in terms of a prohibition.
To go back to the initial question, your opposing counsel said that Powers incentivizes people to violate 1.8C. I'm not sure I would go that far, but would you say that it invites people to do that?
I don't think there's anything before the court to draw that kind of conclusion. I think what Powers enables...
Does Powers provide a roadmap for people who want to violate the rule? If you're going to violate the rule, this is how you do it?
No, I don't think it does, because they're still, under the Powers regime, going to have to go through the two silos. So take... Isn't
that the roadmap? Silo A, Silo B?
Well,
how to prove, how to make...
But the roadmap leads through a few very important toll gates. And one of the first ones is you're going to have to overcome a presumption of influence and convince a jury of Michigan citizens that when you slipped into a hospice room late at night...
But to overcome the presumption, as you pointed out, you just have to produce some evidence, right? You don't have the burden of persuasion.
Do not have the burden of persuasion, but do have the burden of coming forward to rebut a presumption. And, of course, there's the second silo, which is discipline. Now, anyone who wants to take the risks of that sort of action and convincing a jury under the kind of horrible facts that have been cited in hypothetical and risk their license has a lot to overcome. And that's why I say I think it is not giving the current system enough credit that, oh, it's toothless, it doesn't do anything. I think when you have a system that's operated for 125 years, it's not unfair for the court to expect the appellant who wants to flip the table over, to cite some evidence, even anecdotal, might be something, to say, here's how the problem has permeated through the system. And there's a lot of suspicion, and we think it's bad, and we think it should change, but there's none of that evidence that I think the court can really hang its hat on.
Let me switch gears from how Powers impacts the rule to ask you how the rule impacts Powers. And this is, I think, what Justice McCormick was getting at. Doesn't it change our view of a lawyer when the ethics regime changes from this is not a good idea to you shall not do this? Doesn't it change how we view the lawyer who does it? Doesn't it put the lawyer in even more of a quagmire or in whatever disparaging way you want to view the lawyer, credibility, whatever else, ethics?
I think, to use your word, in the AGC proceeding, I think that's true, because now you're dealing with things that have been more generally prescribed in the past, and now it's a specific shall not. That, I don't think you can deny, has changed.
What's the barrier? I mean, you cited McDougall, but what's the barrier to us saying that if a lawyer now is doing something that's plainly unethical, that's something we may want to take into account when we're crafting the evidentiary rule in cases on how to deal with this? You know, in other words, why can't it impact the common law? I don't think anyone up here thinks that enacting the ethics rule has the force of a statute, for example, or a substantive rule of law. The point is, though, that when that regime changes, isn't it something we can consider when we're thinking about whether the common law rule that has existed for 100 years continues to make sense?
And respectfully, I don't think so. And one of the overarching reasons is, I think the case came up at some point this morning, the Tarian case, which talks specifically, let me take a step back. The argument that was made a little earlier this morning was about conflicting public policies. You have perhaps the MRPCs, which may be a source of public policy here, and you have the very clear public policy of EPIC and the common law in the area of probate of enforcing testator intent. If the court were to walk down the path of transporting, let's assume for a moment for the purpose of argument that 1.8 is a public policy. I don't concede that, but let's assume it. Were to transport that from the MRPC rule into the substantive law of probate, I would suggest to you that the court would have done two things. Number one is it would have injected a non-substantive rule of law that is, Justice Zara talked about this morning specifically in its comments in Rule 1.0, is not to be used for litigation purposes and a host of other things.
So let me just jump in there, because I find this somewhat confusing to me, because often the rules of professional conduct find their way into legal, to lawsuits, right? And
You're speaking Evans and Luptak and so forth?
Well, there's the attorney fee contract. I just wrote an opinion called Purgu on the reasonableness of attorney fees. We look to the rules of professional conduct. I think they come into play when we're trying to determine if a lawyer has committed professional misconduct. I think there's lots of litigation, lots of lawyers, probably your firm has in the past argued other lawyers should be disqualified and not allowed to represent an opposing party based on the rules of professional conduct and a perceived or actual conflict of interest. So am I to believe really that the rules of professional conduct have no role in any court proceeding? Is that what you're advocating?
I don't think you need to go so far as to say they have no role and are simply irrelevant to everything. But what the court would be doing is taking that rule and engrafting it over another public policy as expressed by the legislature. And the second thing, which maybe even is more important, and I mentioned the Tarian case a moment ago, which noted Supreme Court case 2002, as a general rule, making social policy is a job for the legislature, not the courts. This is especially true when the determination or resolution requires placing a premium on one societal interest at the expense of another. The responsibility for drawing lines in a society as complex as ours, of identifying priorities, weighing the relevant considerations, and choosing between
Counsel, I'm going to
alternatives.
interrupt you. I don't know exactly where you're going on that point, but I mean, I'm just going to share with you my thoughts. To me, you're really skirting what increasingly, at least to this one justice, is the critical argument in this case, and it is the one raised by my colleague, Justice McCormick here. Are the circumstances in this situation genuinely reflective of a bona fide testator intent, or are they irretrievably distorted by the conduct of the attorney in this situation? In other words, do we have a genuine sense of testator intent that your course of action, the status quo, is facilitating in some reasonable way, or is it simply a deformed understanding of testator intent? That, to me, is the dominant issue.
Okay,
I mean, I'm persuaded testator intent is a more significant consideration than whatever can be implied from the court rule. It's substantive, it's statutory, it's deeply embedded in history. It's not taken piecemeal in the way that the court rule is, but still is testator intent so deeply and irretrievably distorted by the circumstances that arise in these kinds of circumstances that it's not really being balanced in the process in any meaningful way.
And that question, I think, is why I tried to start.
Well, you better do it quickly. You've got about 16 seconds to go.
It's not.
And Justice Bernstein didn't even start yet. So.
It's not. And the simple reason is because when you undertake the inquiry of powers and look at the underlying facts of the case, a jury is going to make that determination one way or the other. Either there is evidence here that can corroborate testator intent and in effect, authenticate the documents, or there isn't. But that's going to be a very specific factual finding across a range of cases.
So I think I'm just piling on to the last two questions. But so the powers rule was envisioned as a way to try and deal with what was viewed as a somewhat corrupted instrument, right? And it was somewhat corrupted because there was at least a ethical norm that lawyers don't draft the instrument to benefit themselves. Well, when it's more than a norm and now it's a mandatory prohibition, wouldn't you have to concede that it's at least a little more corrupted when a lawyer jumps over that line? I mean, in the past, the lawyer's like doing it and it's not cool, man, right? But it's not absolutely against the rule. So a lawyer who, it may be that this doesn't come up, we don't have the empirical evidence that we're talking about because it doesn't come up very much because most lawyers, once 1.8c was, I mean, once the rule was enacted, thought, better not do that anymore. I'm going to send the case down to, lawyer so-and-so down the road, right? So it just doesn't come up anymore. So when it does, it's so extraordinary that a lawyer has jumped over that line that shouldn't we think that the corruption is at least more significant than it was when there was no mandatory rule? And doesn't that mean that at least the test has to look differently than it did when there was no mandatory rule?
Well, and I think that's why I was talking a little bit earlier about the modicum of proof when you're talking about overcoming a presumption, that depending on the facts and circumstances, I think that's an appropriate thing, certainly, for this court to look at.
So your answer really isn't that the rule is irrelevant to the powers rule. You think it is relevant. You just think the test needs to be jiggered with a little bit. We can jigger the test.
The only part I'm really quarreling with at all is the idea that 1.8 is really that significant a departure from what came before. I understand mandatory and permissive, and that's clearly true. But I would suggest that none of the cases that came under the previous code, certainly not Powers, suggested that this was somehow not a violation. I think 1.8 codified that and made it much more clear, but I don't think there's as much light between those things as perhaps my opponent does.
Okay. Are there any further questions? Thank you.
Thank you very much.
Does he have any time left? Sorry, there's no time left.
Thank you, Your Honor.
Are there any questions, though?
I would like to address that
No,
last point if the court is
There's no
interested.
time left.
But I'll let him address. I'd like to hear the last point.
He'll always rescue you.
Never put in a question form.
Oh, tell me about the last, if you could.
Do you have any reactions to the last?
Yes, do you have any? Because in fairness, he kid asked for the 5-minute, reserve. So, can you tell me about that last point? What type of reaction do you have to the last point?
Yes, Your Honor. I think something fundamental has changed since Powers. Under the Powers regime, there was sort of a spirit of ethics. You weren't probably supposed to do this. And so under that regime, it might have made sense to have sort of a nebulous rule that balances, well, if you weren't supposed to do it, but maybe we should still have a trial to figure things out. Now it's an absolute prohibition. So the something that has changed is now we have a lawyers shall not do this ever under any circumstances. And when a lawyer, we're all charged with knowing the ethical rules and following them. And when a lawyer chooses to violate the rule, the consequence should be that the lawyer can never inherit. And as Justice McCormick pointed out, it is exceptionally easy for any of us to honor a testator's intent in this situation by just walking the decedent, the testator down the hall or down the street to another law firm. And when we choose not to pick that easy option in favor of violating a clear and unambiguous ethical rule, it's going to be on us. We are not going to be permitted to inherit because it is then us it is the lawyer who has stymied the expression of the testator's intent. Your Honors, I think this case raises tremendously important issues for the court as an institution and for the integrity of the legal profession.
Because I have a question, and this is just something I'm just kind of curious about, and help me to kind of understand it. It's a little tangential, but I'm still a little curious. I'd like clarification. Is it my understanding, because in the materials, it was talking about the fact that this is dealing with non-family members. Is it, to your understanding, can a lawyer draft a will for family members?
Yes, Your Honor, and the rule addresses that in the last clause, except where the client is related to the donee. So if you are drafting a will for a family member and leaving yourself money, the ethics rule does not prohibit that. It is only for a client who is unrelated to you.
So here's my question, though. I mean, we've been talking about public policy, and I think this has, been a very interesting case. But we're looking at public policy issues, right? And a lot of this is kind of being guided by what is kind of in the public policy, what is in the interest. So going back to this issue of family versus non-family, and looking at it from a public policy perspective in terms of where you're going to have the most litigation, if you look at the rule kind of as it stands, doesn't it kind of invite more issues? Because don't most of these issues actually happen more within families than out of families? So looking at kind of the way the rule is written, you know, looking at the family dynamics and looking at kind of internal versus external, from a public policy perspective, how do I evaluate this with the basis of the fact that most disputes when you're dealing with wills tend to be within families rather than out of families?
Your Honor, I think that's a very interesting question for the court to ponder the next time it is considering whether to revise the rules of professional conduct. There is no lack of clarity in the rule as written that it is okay to do this for family members and it is not okay to do this for anybody else. That's the rule we ask the court to enforce. And
right, but I know I hear what you're saying, but do you see how from a public policy perspective it kind of allows us to have to look at the rule in a more scant way based on that provision?
I guess I don't specifically understand the question.
I guess
Your
the
Honor.
question is, do you see
I agree there
flaws
could be
with
there could be additional problems
Right, okay.
with drafting this. A lot of these concerns could come into play when a lawyer drafts a will for a family member and leaves himself some money in that. And there might be disputes that center on that. All of these same concerns might arise in that same situation. The court in 1988 made a judgment that we're going to carve out the family sort of situations from this rule and just make clear that lawyers that are not related to their clients are not permitted to do this under any circumstances.
Thank you, counsel.
Thank you, Your Honors.
Submitted.